I'm pretty sure this year started showing up. Maybe also. What do you think?
Front and center. Yeah.
Yeah, I'm like,
Yeah.
That's what I did yours.
Well, give them a few minutes or. They got the link, right? Yeah. All right, well. Oh, they can order and get started. We expected two members to join us virtually, but don't see that yet. But we do have a quorum present, so we will begin. First for the minutes.
Yeah, everyone should have, received the September minutes. And this is a chance to make any changes to those minutes. At this time, does anybody have any changes? Motion to accept the minutes?
Motion.
Second. Second. Any further questions? No. Motion to adopt the minutes. Aye.
Aye.
Okay, motion passed. On to the operations report, Mr. Kelly.
So we have a new data system. I'm sure that everybody's familiar with the struggles with like the rest of us there. But in the new data system, as of what date you notice?
Friday.
Friday. As of Friday in the new system, we had 13 LSWs, 136 CSWs, and 167 LCSWs. So that's just in the new system. So that's terrific. In the old system, applications are LSW 1, CSW 9, LCSW 10. Renewals are LSW 13, CSW 58, and LCSW 102. We had 14 clinical temporary permits. There were 83 supervision contracts, and that was a mix of the new electronic contract and hard copy contracts. There was 0 deferred. And permission to provide supervision, there was 5 that I approved, so we got 5 new supervisors of record. I processed 2 applications for providers of CEUs and 6 sponsorships. For some reason, this month sponsorships were really big. And according to the new system, we have a total statewide of 8,286 licensed social workers.
All right. Good deal. Questions for Kelly? Like, I know the big question is about the licensing verification system, so we're still offline enough. We're having to do those manually still, right?
Yeah, be patient with this because right now, there's no way to verify a license on the new system. And we've been assured that that's coming anytime soon. So right now, we're doing them manually. And just me and my email today, I've had 40.
Same.
So it's, but we've got a lot of new social workers.
Right.
So that's why we're getting so many more verifications.
Right. So, but Brooke, all of y'all working together to get that
Yeah,
out, so as quickly as possible, so.
it's possible.
Sure.
Yeah, so has the new system impacted the way in which applicants are applying already, or is it just changing the way in which we process them?
Well, it changes in the way that we process them, in the way that, the software is completely different. I mean, it's just completely different. I mean, we're still working out of 2 systems, but I mean, we still require the same things from the applicant. So that hasn't changed.
Got it.
but they have to create their own account. That's the only difference.
Oh, I see. So they can't just email it, they have to create an account, put
They
it
have
in.
to create an account, put all the data in. And that gives them freedom over their account. I mean, that, they can edit that, they can update their address, their name, email address, they can update whatever they need to. They don't have to email us and ask us to do it. So they can do it on
It's their profile.
their profile.
Anybody else? Okay, there's Whitney, welcome. Any questions for Mark, Janessa, or Whitney? Okay, any motion to approve the operations report?
Second.
Okay, all in favor? Aye?
Alright.
Aye. All right, motion passes for the operations report. On to committee reports. Whitney,
Which one?
finance committee.
Okay, financials. Okay, sorry, I was just trying to get everything in order here. So for finances, our September revenue was $45,230.13. Our expenditures for September were $56,477.88. Our revenue to date is $135,260.13. And our expenditures to date are $123,025.75. And then so again, our yearly allotment for the fiscal year is $838,600, which leaves us with $715,574.25 that is unexpended and unobligated.
And a little extra expense there in is that our quarterly on IT stuff and rental property?
Yes.
Those two items, right? It's our quarterly, is that it? Okay. Okay. Questions? And Whitney, Koan has agreed to join you for the.
Awesome.
finance.
Great.
Y'all can
Hello.
coordinate. Thanks, Tom. All right, good. Next up.
I don't have my agenda pulled up. Do we need to, I need to make a
diem.
motion, move that we approve the per diem for today. Is that what's on there next?
You're right, per diem for today. Second,
Second.
all right, all in favor? All right,
Aye.
all right. Need a motion for per diem for the chair's travel to the KASWE.
Second.
Well, I can't make a motion.
Oh.
I could, but technically.
Ready.
Make a motion to, for coverage of the travel for the board chair, ASWE.
Thank you.
Second.
Okay. Any questions? It was a delightful meeting, thanks to the University of Pikeville, delightful meeting. So all in favor? Thank you. Now, we move on to your committee, applications committee. I think Janessa's got a report, right?
Yes.
Okay.
All right, we have 5 applications that Laura and I reviewed. The first application was a new app. It was one we have not reviewed before. And this application, this person had a felony, actually multiple felonies. And the paperwork that they sent us was for felony expungement eligibility. So it wasn't showing us that it had actually been expunged or that that was no longer there or what the process, if everything had played out. And so we really, with this one, would like some legal guidance because while we can't make a decision based on the felony expungement eligibility paperwork, we were also very concerned that this individual had, if I counted them correctly, 13 different assaults or violations of an EPO or DVO. And many of those were not eligible. If it was a second offense, they weren't eligible for expungement either. So I was hoping that Mark B could kind of guide us a little bit in what that needs to look like, and whether or not, these felonies would have any implications for us.
I think this is the first, we've always had the recovery person, not assaults.
Yes,
Right.
this is Worker Legal Counsel, and the Applications Committee may indeed deny the license based on lack of good moral character, as evidenced by the multiple criminal convictions in their record. What I understand is those records show that the convictions are not even eligible for expungement. So they had to be disclosed, and they were disclosed. There is a statute, KRS Chapter 335B, which governs the standards for denial of a license, and I've reviewed those standards, and I conclude that you meet them and can deny the license. However, the denial does have to include language that they can request an administrative hearing and challenge that denial, and that would be a hearing, a trial before the board.
Well, I think that's kind of what Laura and I expected to hear from it. And so, and Laura, correct me if I'm wrong, but I think based on our discussion that it is our recommendation that we deny this application based on the multiple violent offenses that were disclosed to us.
So motion from the applications committee, which is a committee of one or more than one. It doesn't need a second, and it's on the floor for discussion.
Do we know when the most recent charge was?
Yeah, give me just a second and I'll pull that up for you. And they were over many, many years. I think they started as early as 2015, wasn't it? Laura, if you've got it pulled up and you want to. I want to say the last one was maybe 2022, but I couldn't swear to it. It's been a few days since we reviewed.
Do we know if time was served for those already or no?
None of that was presented to us. It was all they sent us was the felony expungement eligibility.
I'm seeing 2017.
Was that the last one for the assaults and violent offenses?
Let me see here, hold on.
There were a couple of pages of documents to go through with that one. Let me pull it up too.
I see one in 2007, but then I see violation of EPO and DVO in 14.
It's on.
Yeah, it goes on,
It
so,
goes on from there.
yeah, so,
17 might.
But we're back as far as 2017.
yeah.
It might be the last.
I guess the biggest concern Kevin, that we had with this one was that there were multiple violations of the DVO or EPO. So it wasn't, that's why they weren't eligible for expungement. It wasn't just a one-time issue. There were multiple assaults and then violations. So it was, and it was, over a period of a couple of years. And these are not recovery, usually what we see are recovery or, some sort of drug related offense. I don't know that I have seen in what time I've been there, violence against people. You know, usually it's a property crime or something. And so this one was very concerning, which is why we wanted to seek legal advice on this one.
Good questions?
If I could weigh in, I would just say
Sure.
that I would support what Mr. Brinkelman said, that if, you know, if we do deny it, the person does have a right to a hearing and they can talk with us. And if there's, you know, other information that wasn't included, that may, you know, change our minds, they would have an opportunity to share that.
Right, their due process would be still recognized, it wouldn't be like permanent.
Right. And we welcome that. Absolutely, we welcome that.
For the vote today would be permanent. Okay.
As an educational point for myself, would we have limited statute, or like would there be a period of time from when somebody has a felony to which we would say this should last 10 years, 20 years, or is it just kind of indefinite based on moral character? Just for future cases, I want to understand like what would our.
It's a good question, and it's not really one that I can answer. I don't know if there's anything in the statutes that tell us that. I'm not sure. I mean, if this was a felony from 1970, I don't think that we would be very, you know, as concerned as we are about this being as recent as it is.
Anything else, Mark? Anything else?
And also, Kevin, I'll just reiterate that for us, it wasn't an issue that there was just one violation or assault. There were multiple. And I mean, the list, there was, I think, 2, maybe 3 pages of felony charges that were listed with the felony expungement eligibility. Some of them were eligible, some of them were not. And those that had been repeated were the ones that had not been eligible for any type of expungement. And there were multiple of those.
Vote will be to deny the license. They would have a chance for a hearing, so we could maybe have more information. So again, when we act, it's, you know, for the public safety, so. Any other comments? In favor of denial of applicant 1?
Aye.
Aye.
All right.
I to denial.
All right. Application 2 was one that we have reviewed before and had asked for additional information, and they provided that information. So we recommend that this person be approved to sit for the exam.
Okay, question? All right, all in favor?
Aye.
Okay. Application 3, same situation. We'd reviewed this one before, had requested information. They complied, and we recommend they're able to sit for the licensure exam.
All in favor? Aye.
Aye.
Application 4, same thing. We reviewed it before. They sent in the information that we had requested and that was needed, and we recommend they be approved to sit for the exam.
Questions? All in favor? Aye.
Aye.
And then finally, application 5, same situation. We've reviewed it before. They sent the information we needed, and we are approving them to sit for the exam.
Real theme here, right? Got all the information we need.
We love doing those. We love doing
Yeah.
those. It's just the ones. The first one was harder for us this time. We spent a lot of time talking about that one. Yeah.
I'm sure you did. It was needed to. Anything on 5? All in favor?
Aye.
Okay.
That's all. Thank you all.
Thank you, Applications Committee, and Application Committee, Sydney has agreed to join you.
Yay. Welcome, Sydney.
Welcome.
learning the process. And Mark may even show you the software too, if you want. Anyway, all right, not a bad idea if you really have time to do that part. All right, so now we're on to our complaint committee.
Okay, now so this could get interesting because I have a handwritten notes and a computer over here. So if I misspeak, just please correct me. The first case to report on is case number 2474. The alleged violation is fraud or misrepresentation. And after reviewing this, the committee moves to issue an assurance of voluntary compliance.
No fraud was found, but some other issues were found, but
Record keeping.
record keeping, biggest challenge was record keeping,
Mhm.
some issues there, so. That's all.
And I think we've explained, just to make sure that we've explained before that assurance of voluntary compliance is not technically a discipline. Or that's correct,
Yeah,
right?
correct, right, it's kind of we'll give you a warning on speeding ticket or something.
Mhm.
Okay, any questions? All right, all in favor of the ABC? Aye.
Hi.
Okay.
Sorry?
Shoot. Is it too late to ask a question?
Yeah, go ahead.
Okay, so with the issue of voluntary compliance, is that the phrase?
Yes.
Would that be something that would be on their record, like if somebody were to look and see? Or is it just
It's internal, it would, if they had another complaint, the committee would review that.
Gotcha, so like a verbal in a way, or
Yeah.
written verbal.
This is Mark. Let me supplement Hank's conclusion to say it is not discipline. It does get reported in a newsletter or on our website or to the National Data Bank, but it is a public record if somebody ever asked for it.
Got it.
Or an employer asked, have you had your license revoked or suspended lately? No. Have you an assurance of voluntary compliance? Yes. That's a public record. It's not discipline.
Good help.
Yes.
Yeah. Okay. All right, next.
Okay, case number 2476. The alleged violation was impaired practice. And the committee has reviewed the documentation and recommends, makes a motion to require the licensee to have a mental fitness exam and a hair follicle test.
Different one for you. Well, occasionally we have these, our statute, our regulations require us to have an outside discipline. Somebody in our discipline to do the evaluation, so there's no question about conflict of interest. So we would be finding referrals for them and paying for it. So it's not out, they're not out the expense of getting the evaluation done.
Wait, can I ask a question about this just because I'm curious?
Sure.
Is this person independently employed, like has their own shingle, or do they work within an agency?
Good question. I'm trying to think about that one.
Just curious that if the agency does drug testing regularly
I'm not sure.
It's she's in an agency.
in an agency.
Right.
Okay, I was just curious if agencies do.
Don't know what we want outside.
Right,
outside.
right. I was just curious if maybe there was some sort of a pattern, perhaps. Maybe it had been reported before or something. Just curious.
Just first time as far as we know. Our files.
Thank you.
Okay, you're welcome.
Would the results be reported to their employer?
No, it's just
Okay.
so.
Now, I don't know that their employer would even know about this process unless they requested that through an open records request.
Right, they could, right.
But clear.
Which I think is kind of interesting when you're talking about protecting the public. what we find out, if we don't share
Yeah.
beyond that, right? So I don't know. It's a precarious place to be in, I think, to protect confidentiality of our social workers, and then, also protect the public. It's hard.
Mark?
If you opened an investigation, for example, the employer would be an obvious person to interview about their employment history and their personnel file, and they'd find out that way. But otherwise, they're innocent until proven guilty, and you're ordering a drug screening test and a mental health evaluation, which you're specifically authorized by regulation to do as part of this complaint process.
Further questions? All in favor?
Okay, case number 2512. This was an allegation of a dual relationship or boundary violation. The committee found that there was insufficient evidence to support the initiating complaint and recommends dismissal. Or moves to dismiss.
Move to this. Substantiate enough. All in favor of dismissal?
Um,
Aye.
Okay. Case number 2563, the allegation related to the licensee not having correct parental consent. And in case number 2563, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Question? Okay, all in favor?
Aye.
Aye.
Aye. Okay, case number 2568, the alleged violation was client abandonment, billing issues, and incorrect documentation. So in case number 2568, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Did not find evidence of abandonment.
Could there be an instance in this situation, because it sounds like there was 3 allegations with the documentation, the abandonment and the money, where they could be found on a couple of these
Yeah,
situations?
right.
But in this one, we have insufficient evidence across the board.
Yeah.
Okay.
Yeah, sometimes these complaints are kind of obtuse, like lots of information, and we sift through it and go, is there anything here? And there have been situations where what we actually ended up bringing, a discipline about was not even what they complained about. It's that they complained, and then we started looking at things more closely and went, well, that's not actually anything we can act on, but this is. So, yeah.
Makes sense.
All in favor?
Aye.
Okay, case number 2571, the allegation related to incomplete documentation. In case 2571, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Questions? All in favor? Aye.
Aye.
All right, case number 2572 was an allegation of a breach of confidentiality. And in KBSW case number 2572, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Sure.
And on the form, I've not seen the form. Does it have something on there that explains, insufficient evidence may be a result if not provided with whatever X amount of information? It seems like we have that result a lot, and people know exactly what they need to provide and what's going to warrant that outcome.
Oh yeah. Yes,
Okay.
we do frequently. So there's like lots of cases that come in every month that we don't even report on. And a lot of times that's because we've asked for more information. So we kind of sift through those. We just don't give a whole lot of detail in the meeting to protect privacy. But we do regularly, yeah, and that's a great question. We do ask for extra information on a regular basis or even subpoena information.
We can do either.
Yeah.
Hopefully they voluntarily send it to us. We've had a couple of cases where we've had to dismiss because we never got what we asked for.
Yeah. Got it.
Yeah.
And sometimes the complaints are 1 cent.
If they knew that if you don't give enough information, then this is gonna be the result, just so people aren't frustrated.
If it's gonna be dismissed like this, it doesn't mean they can't refile it with the right information that can help us.
Who all is given, our verdict? Like, who all
There was
receives-
a complaint that responded.
Okay, so both.
Thank you.
All in favor?
Aye.
Okay, case number 2588. No, 2585, sorry. That was an alleged breach of confidence. Is that the one I just reported on? No.
No.
It's not. Okay, sorry. All right, 2585 was an alleged breach of confidentiality. In that case, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
All right.
All in favor? Aye.
Aye.
One other thing I would note, I don't think we said earlier, is some of these cases we did receive extra information, and then after receiving it, we decided it still doesn't support. Okay, so just wanted to throw that out there. Case number 2586. The allegation was unlicensed practice. This was a licensee whose license had lapsed for a fairly significant period of time. The committee, in case number 2586, the complaint committee moves to issue a letter of admonishment, which is a disciplinary action. Because that is pretty serious. This was for several months, and the person was not overly concerned about it in their behavior with our executive director. So that's concerning.
Yeah.
So this, were they working in private practice or for an agency?
Agency.
For an agency, wow.
Yeah, so the agency has a significant financial loss. That's not our, but that's the impact of what the person did. Going with the letter of admonishment. Good. All in favor? Aye.
Aye. Okay, case number 2587, allegation was alleged harm to clients. In case number 2587, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Is there any more information on what type of alleged harm?
Is that the one? Let me look. Let's see which one. 2587. We had like 15 this month.
Oh.
This
was the sudden drop case.
Yeah.
Yes.
Right, the person was discharged and they felt it was done incorrectly and whatever that they were harmed by it. It would have
This is the one.
wasn't abandoned because the person had gone through the steps. But there may have been.
Can we say the person was handling a delicate?
Discharge that we would prefer not to discuss in public, because it's very personal nature. But the allegation that harm doesn't seem to hold up because of the steps that the person doesn't. Social worker for discharge.
So the clinical issue is simply, is there ever a circumstance that you would terminate and refer to other therapists on the spot in one session? and say, I'm not seeing anymore, this is the end of our session, let me give you a list of 3 people in the county that you might want to go to. Is that ever a possibility? Or is that client abandonment? What do you mean you're terminating me? Could I not have 2 more sessions just to wrap up? No, we're done now. I think that's a clinical issue that you all know the answer to. I don't know the answer to, but I think it's legally defensible as not patient abandonment.
Right. The person had 8 steps before that.
Okay.
Okay, all in favor?
I,
Okay, case number 2590, the allegation was that the person was unresponsive to the complainant. I think this is the one where it seems to be mistaken identity. The complainant complained on a social worker. It's someone that works for the state, and this person's like, I don't even know who this is. This is not someone on my caseload.
Right.
And even if they were, I can't respond to someone who's not my client. So
Right.
the committee moves in case number 2590, the committee moves to dismiss due to insufficient evidence to support the initiating complaint.
A little different, but
I,
okay, all in favor?
Just we just have 2 more. Okay, case number 2592, the allegation was a hostile work environment and something to do with the paycheck, so it sounds like kind of employment stuff. In case number 2592, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
We don't, can't get into employment issues.
Right.
That's not out, that's out of our purview. All in favor?
Okay, final one, case number 2596. The alleged violation was that this was one of those ones that was long and it possible retaliation for a complaint that somebody, I guess the person, I don't know if I'm going to be able to say this straight. One person filed a complaint against another in the past, and so this complaint is saying that that was in retaliation because they had maybe filed a complaint before. Is that, Hank, can you say that more clearly?
Right,
Yeah,
counter complaint because of the other complaint.
Yes. So in case number 2596, the complaint committee moves to dismiss due to insufficient evidence to support the initiating complaint.
Questions? Okay, all in favor?
I,
All right.
I do have, if we're not too far removed, 3 ago with the mistaken identity, did we have the, like the information, like to confirm that it was the correct person and the person being accused that it wasn't me?
Yeah, I don't know this person. What do you, we've had this twice before when there's something. We've had people with the same names get complained on, but it's not the person.
Okay.
Person, so we have to get the identity straight of the client as well as the licensee.
So is there any follow-up on our part where we have to try to figure out who the right person is, or is it just kind of like?
We already, we've done enough on that to do it.
Got it.
Well, and this is also one of those cases where somebody's angry with something related to child protection, and that seems to be what's motivating the entire complaint. Not, I mean, no clear real allegations of, oh, you did this thing, and this is really, it's more like, I don't like this decision and I want somebody to respond to me.
Yeah, so it wasn't a specific person, because I was just thinking, could there be a world where if somebody complained on me, and I'm just like, I don't know that person. Even if I do, but I'm just like, I don't know.
Yeah.
Where I could just say I don't, even if I do, and it's just dismissed as well.
Well, that's not outside the realm of possibility. Maybe the dismissal letter back to the complainant, I've never thought about this. Maybe the dismissal letter back to the complainant should say, according to the response of the social worker you complained against, that social worker has no relationship with you, not a patient, not a client, not a former client. And if they had evidence to the contrary,
Then they can
they
present.
could present it again. Otherwise, you could lie and get away with it if you just said, oh, I don't know this person.
Yeah, I think about that old song, it wasn't me. Just keep saying, it wasn't me. Okay, I think for that, it'd be that simple to get out of something that they might have actually done.
I've never thought of it, but I think you could put an extra sentence or two in a dismissal letter. You know, there are other contexts, like in physical medicine, large dental practices or dental chains where someone has a continuing dental problem. And, you know, 7 or 8 visits later, they're still in pain or whatever, and they make a complaint. Even when you get the record, you can't always tell who was the practitioner they saw that day because the records are so bad. They saw someone different every time they walked in and said, I was here yesterday and I still hurt.
Yeah, I can see that being problematic.
That's why there are some record keeping laws in those that say the practitioner of record has to be clearly stated for each visit. Because even the dental office couldn't figure out who they saw that day. They came in 7 or 8 times and saw someone different every time.
Right.
But you could otherwise just lie and say, oh, I don't know this person,
Never met
never met him.
them. Okay. Thank you for the clarification.
You're welcome. New board member training, how was it?
It's great.
I agree.
Really informative. The whole staff, all the trainers were lovely. And it was just really helpful to solidify that wear your regulator hat, not your clinician hat, or even your administrator hat. Completely get rid of those because it's not just the clinician hat, but also if you're an administrator, you also that hat as well. So that was really helpful for me.
There was a lot of, actually, I noticed that the majority of the people there were actually non-social workers, which I found to be very interesting. So we got to learn a lot on the administrative nuts and bolts of what does the ASWB do? I was able to have an unlearning of the role of ASWB, whereas I assumed that they were basically the ones that told our individual boards what to do, where it's kind of flipped on its head, where they're actually more in support of us. So that was something that I thought was very valuable information, just kind of understand the process. There have been a lot of concerns about inequities with the test taking, the LCSW exam, and they were able to clarify the steps that they take to make sure that there's, you know, good equity and diversity included as far as the questioning and how the test is administered. Thought that was really good. So I'm learning about just the different steps that they have to be able to support our board and to be able to help us with understand some of the processes. They're like, oh, okay, that makes kind of sense. So I learned how little that I knew. So
Which is
still,
usually a good thing. I mean, you know, so you're constant state of learning.
absolutely.
Usually a good
So
thing.
still a lot of questions. I'll continue to be inquisitive.
That's okay. That's how we all are. Yeah. It's a challenge to keep up with everything.
Oh, yeah.
I'm just glad y'all could go and really appreciate you taking the time to do it and everything.
Great
And
experience.
Kwan needs to tell you about his after he got home.
I didn't get to go home, so I went straight from driving from Alexandria, Virginia. My wife drove. Went straight from driving 10 hours to get to the wrestling ring and won the OVW United States Heavyweight Championship.
Now you have to travel around and defend it, right?
Yep, so then I just got back from Wisconsin defending it.
One, two.
Yep.
Good. Very good.
Congratulations, Quan.
I appreciate that.
Good, good, good.
Busy weekend.
Yeah, next is delegate assembly. Don't know who all's gonna be able to go
In Indianapolis.
in Indianapolis.
Sure.
You're not sure, however.
I will be there as a representative of the nominating committee, but I can also be your alternate if needed.
Okay,
But
Okay.
anybody else should come too. If you can, it'll be great.
yeah, not too far to drive.
Yeah.
I guess, so good, beware. of that.
What are the dates again?
Well, it's the 6th, 7th, and 8th, but the delegate assembly is actually 7th and 8th. The 6th is the day before, and they have a board member exchange, and administrators exchange meetings that are a good way to kind of learn a lot of other things from other boards. They have specific topics.
It's Friday and a Saturday.
Yeah, Thursday, you go to the pre-conference.
Right.
The board member exchange, I mean, I was told when I started going, that's just as good or even better than what you get at the big.
Yeah, right.
And it's true. I mean, you really have a lot of opportunity to meet people from other jurisdictions and exchange information and strategies about, here we have similar challenges, but how do different people address this in different ways? And it's always fascinating because we're there with people from, huge jurisdictions and then people from, areas that are similar to ours. And we've always gotten a lot of good ideas um, in that setting, those meetings.
Mhm.
First time I went, I got more, like what you said, I got more out of the board member exchange than I got out of the meeting, because it's a business meeting.
Right.
It's not all super exciting. Sorry, it's just the way business meetings are. They're not all super exciting.
Except for this one.
Yeah, well,
This one's pretty exciting.
ours is. Okay, good.
It's
Thank
just
y'all.
because of the people who make it up, though, because
Oh,
we're
yeah.
pretty fantastic people. That's what it
Yeah,
is.
Well,
That's very
it's like, we're a fantastic group. We're the board. But again, it's also good, especially because we're also connected with the Canada provinces. You get a little different flavor of how they operate. So it's just a good exchange. And I know the administrators exchange, they do the same. So, yeah. You got a lot out of those. So always. We always get there early to do that. Of course, this year I have to be there one day earlier. So I'll tell you about that shortly. You already got a little bit of the update about the application software from Mark and the operations report, but we're still hopefully getting the verification piece, license. That's the last piece that, we were hoping it would be live last week, but it didn't make it. So that we are ready for all of that to be in place. The contract software is still working online for the contracts, saving some steps in that, getting that. Is there anything you want to comment on?
It's like the electronic contract is an amazing process and it is such a time saver. And once now people have had a hard time, like, understanding, that it takes a licensee, supervisor of record, and HR director all have to complete their sections before I get it. So if I haven't gotten it yet, that means that somebody hasn't signed off on something. So I get it at the very end after everything's already fixed. So,
Which is exactly the same way the mail system is.
right,
It's just that the CSW has to start it.
right.
The supervisor record has to do their part. And then the HR has to sign off on it.
And it's all electronic. I mean, it's amazing. I don't have to print anything. I mean, nobody has to print anything. Nobody has to, I can read the writing, which has been really, really helpful.
Yeah.
Cause not everybody has
Handwriting.
penmanship, including me.
Yeah.
But, but it's amazing.
Yeah, so we encourage the CSWs to start it and get things in process, contact the supervisor of record. Like I said, if they call here and you haven't seen it, that means either one, the CSW has to submit it. So if they forget to submit at the end form, that it doesn't go to the supervisor of record to, and each person at the end gets a email notification that it's done. So,
People have been forgetting to put the HR director's email in.
yeah, so it stops.
Cause it causes you to think about, the contract, globally, that, that it's part of the agency that you work for and if they need a copy. So,
Gives everybody that, so we're.
Now, do the supervisors, are they able to upload into the portal or do they have to give it to the CSWs who then upload it into the portal?
actually, it's automatically uploaded into the portal. When I submit it. And then I, copy a PDF just for my files. So I've got them handy. In case there's a question or anything and I can.
Well, I'm thinking before it gets to you, like if I'm supervisor of record am I going in the system and filling out my part, or am I doing my part, giving it to CSW and then they put it?
CSW starts,
Starts it, okay,
and then when they finish, then it's emailed to the supervisor record.
I got it.
Then supervisor record, because they're part of it, then it's emailed to the HR director. Then the HR director signs off. it goes to-
Okay. Tracking.
Yeah, it's really cool.
Good. Excited about that. Hopefully, maybe it's what we can do, like the documentation, experience forms and stuff like that, if this works out. So that supervisor, all supervisors on that contract can submit that, so it all comes in, so that they all be tied together, so that's the next step. All right, somewhere compact, and as I said earlier, the next meeting of the Compact Commission is November 5th. If you want to join in on that meeting, it will be in Indianapolis if you want to come in person early. This will be our designated as our annual meetings, because we're still due, so we're designating this as our annual meeting. It will probably always connected to the ASWB meeting the day before, because as delegates to the commission are often also coming for the ASWB, so it's doing that. We have a rule for the rotating ex officio member that has to be approved. We have the rule for the data set to be approved, and we have to discuss how the data system will work. How that will work, and we'll have our discussion about fees with the commission, because there's going to be a fee obviously attached to that multi-state license, and funding for the compact, because we're still working on that. We have to ASWB, we're working on MOU with ASWB for the funding piece of it, and that that's part of that discussion. Because of the delay in the software kind of working right, Whitney, that would be best for us for surveying our licensees, waiting till after it got all online first. So I didn't send that out. So if they can wait, we'll send that out. Hopefully, maybe have some information before we have to start setting fees or discussion of that. And plus, it'll be after the compact meeting, which may give us some more information to talk about. Any questions about the compact? Not that I can try to answer. We have to get all these decisions made. Hopefully, as many can be made at the November meeting as not, so that we may be in a position to start projecting a timeline, because we have to hire an executive director, we have to have a place, an office, all of that logistic stuff has to be worked out. And everybody's hesitant to give a timeline to anybody because something could happen. And we might not meet it, so we don't. But just to give you a little context, is like the counseling compact was passed in 23. Ours was in 24. And counseling compact, I think there's one or two states that are just now issuing permits or privileges for under that compact. That's kind of how long that has taken. So we want to make sure that we're trying to go as quickly as possible. We've got a good, the committees and everything are working really well. And people have taken time to do extra special meetings for the commission. So we hopefully that will continue, and we get the work done and have that ready for everybody. And when we have a definite timeline, then we can publish it so that everybody will be aware of when that might happen.
So with that meeting taking place in Indiana, is Indiana any closer to being a part of this?
They will be at the delegate assembly, and I know some of the people there want it, but legislation kind of thing. We will have to decide we will have a first at this meeting. South Carolina passed legislation, but with the advice of our council, the commission will probably have to not accept them as members of the commission, which is disappointing. But if you pass the compact law, it has to be substantially the same in all the states. And there's, according to council, seems to be not in compliance, so the commission will have to vote on that. But it's 30, Delaware would hopefully have all delegates there for, but we then in September, we had 26 out of 30, so pretty good. All right, regulations, I have today on the agenda because it was supposed to be today on the agenda, but it just got moved to tomorrow. So Mike and Mark will be going to, well, that's the continuing education reg that we get first. All right, move on to the legislation. Send that on to you. Sure, you read every word of it. There's just a couple of things that to start with is that the bill starts with section 1 is so deletion there at the bottom is all in there. Then there's the section for definitions. We run into a difference in the way we define what you have in your handout is what was in last year's provision, and then I copied out what was in the law right now. It's under 158. It's the first time we've had a definition of client in our statute, but it came in through SB 255, and then the quotation from our code of conduct is where the definition was, and kind of the biggest difference seems to be the question about whether or not the 5 years is attached to in the statute or not. And of course, the other question is, do we even need it in the statute? Just leave it in the reg. But since it's already in the statute, either we delete it and just leave it in the reg. So, thoughts on that one?
I'll share with you that I really think that this needs to be handled in the regs, the amount of time in the regs. We don't know when things need to change or things need to be updated at any given time. And it is so much more difficult to have to change the law than it is for us to be able to change the regs to stay aligned with our peers and so on and so forth. So it makes sense to me that that would be included in the regs as opposed to being in the law.
Good.
Would there be a level of redundancy happening in both? I'd like to think one of the things I learned from the SWB meeting was that the statute is kind of like the skeleton and the regs are kind of like the meat, in the sense that it seems as though if it's in the statute, then that would kind of cover the regs also. But I hear what Janessa saying about if we have it in the regs as opposed to statute, it might be easier to update it. I guess this is kind of your thoughts.
Yes. Yeah, because we never know. I mean, things like this sometimes need to change. Maybe there's, I don't know, maybe there's a lawsuit that happens somewhere and, you know, there is a movement or a need to change that, to increase it or to even decrease it. When we have to go change the law, we have to go through this, you know, long process. The regs are a little easier for us to handle. It makes more sense in my mind that those are in the regs and gives the people that are on the board a little more freedom to address that in order to appropriately protect the public.
Made it easier. Is there any reason why, does anybody have a counter for why we would put in the statute versus the regs?
Just gonna ask Mr. Brennan if he had a comment for us from the legal side of it.
Because you want to have a period of time in which the prohibitions on dual relationship, romantic relationships, and those kinds of things continue after the last date of service, you have that in administrative regulation. You don't have that in statute. There's an issue as to whether there's a conflict between what does the statute that says client control over the regulation that says client and for 5 years. So putting that in the statute would close that kind of possible loophole. You could put all the definitions that you say in here and say the client shall be deemed to continue to be a client for a period of time to be defined by administrative or under circumstances as described by administrative regulation following the last 1, date of service, 2, date of employment.
Like that.
I would, yes, I think that would be a great alternative. I just think that the number that is put on there really should be housed in the regs as opposed to in the law.
Yeah, as far as the background, it's like, there was a case years ago where we got the 5 years, because the board was told to basically set a time because we, operated under the traditional thing, once a client, always a client. And administratively and under law, you have to have some demarcation, and other regulations have 2 years, 3 years, or something like that. So that's where it came from. So that makes more sense to do it that way.
So what I think I'm hearing is that we'd say in the statute client, and then that'd be per the regulated definition, and then put the definition of client in the regs.
It's time, I think, is what you're.
Just time would be in the
Just time.
regulation.
Oh, okay.
And you might add some kind of phrase like, and other circumstances. And I don't know what those may be right now, other than time. I can think of one regulation that says not for 2 years, but not for forever if the person is clearly vulnerable by reason of diagnosis or whatever.
Hmm.
That one's never been really challenged, but sure could be. Because if someone says, well, how was I to know that this person with bipolar disorder, schizophrenia, major depressive disorder, you know, everything was a person who was, quote, clearly not capable by reason of mental illness.
Mike, can we help formulate that, just language that I.
I agree with Mark. It's always good to have statutory definitions that take you to a certain point, but in terms of the putting a look back in number in, I think you can do that by reg or by definition. It's just more flexible if it's in.
Do some language here for me on that part of it, that would be helpful.
How about saying, quote, for a period of time to be defined by administrative regulation following the last A, date of service, B, date of employment. And you might add, for a period of time to be defined by administrative regulation and other appropriate circumstances following the last date of service, date of employment.
Gotcha. Sounds good. That works. All right, next one, and again, is the practice of social work. Is the next definition to take it up. And I didn't get to send that out to you because what you see and what I gave you is what was in last year's. So in reviewing what I received from Children's Alliance, I go, whoa, wait a minute, there's a difference here. You know, at first it seemed to be the same as it was last year, but now they changed it. So theirs is a little bit I can read it to you. So then you look at your definition there, practice of social work. It has A and 1 and 2. 2 is actually from the existing statute, and 2 is, B is so it's only in the A is where they're dropping out number 2 and combining 1 into A, and it reads the application of social work theory, knowledge, methods, ethics, and the professional use of self to restore, enhance social, psychosocial, or biopsychosocial functioning of individuals, couples, families, groups, organizations, or communities through the care and services provided by a social worker. that last phrase, provided by a social worker, is where it kind of gets a little different. Our communities through the care and services. That's where it seems to kind of adding that phrase, you know, there. Because this definition is meant to be the practice of social work, so I guess the three levels, the macro, meso, macro, that's what this definition is about. But it's that last part that through the care and services provided by a social worker. It's like it's the practice of social work, not like social work service. It says where I got confused on that.
Right,
That's where I
right.
wanted to, after I read it again, I thought, oh, I needed to send that to you all. And I didn't have time to send it out, but that's where it seems to kind of narrow it. It limits it to kind of like direct care kind of thing rather than and that strikes me as something we needed to discuss. So,
Well, similar to our definition of client, the definition of social work might cause some, I think in ASWB, we were talking about the definition of a social worker as somebody that holds a license and then.
yeah, that was the next one.
Oh, okay.
The next one. What is practice? That's the next one. Who doesn't?
So I think that the definition of social work could impact the definition of that.
It does, yeah.
Okay.
They go together, yeah.
Got it.
Yeah, so, but, to me, that last part is more problematic with, kind of a definition of practice that instead of linking it to direct care, it's just, this is the practice. Direct care would be different, right? And I think leading out and all or provide or improve social and health services needs to stay in there. That's from the current definition. I think that needs to stay in there too. Yeah, I don't know. And
Are you asking, do we agree with it or?
well, I mean, or do you know, it's basically, do we kind of try to go with our language or agree to delete two and take that combination? What I can do is try to put this out, send it to everybody so you can have time to think about it. So we don't have to do it today, just so you can see them side by side on that. Now, the next one is, what does it mean? What is a social worker? That's where this one's a discussion we had, Janessa had the educators meeting. So that's where this language comes from. And I have to tell you that in your, what I sent you, there's probably maybe a critical word missing. You saw that, under number 7 on page 4. Social worker means, individual who has a degree or is licensed or has a other permit or whatever. So that's where your question comes in, right? Like the issue of, because we had a big discussion about, do we really have title protection for being called a social worker? Because we know we've always had this issue of somebody being called a social work person calling themselves a social worker and have no training or degree at all. So the attempt here was to have language in here that would say, if you're a social worker, just like a nurse, if you didn't get trained as a nurse, then you can't call yourself a nurse. Whether you're licensed or not is not the issue. That's the second one, is that you have the degree. We've had this discussion lots. And the educators wanted us to put it in, so we're putting it in.
Yeah, and I will say that this was something that has been talked about quite a bit, and Whitney can back me up on this one with the Kentucky Association of Social Work Educators. It's always been an area where I think there have been some confusion about whether or not we truly have title protection. You know, we say we do, we talk about it all the time, but really the way it's written, we don't completely. And so the educators really ask during the KSWE can we do something about this? Because this needs to be addressed. And of course, we were like, yeah, we can do that. And talked, and they kind of talked about the language and things like that. So this is actually coming from, you know, our educator colleagues who are saying, you know, this is an issue, and it does. It impacts what we say to our students. It impacts, you know, where we place students, how we recruit. I mean, it's a big deal. So we really do need some clarity on that, I think.
It really, our statute is vague. As you know, as we had this discussion, it's just vague. So this is an attempt, this statement, and there's two statements, basically to clarify that issue. So once and for all, because it hasn't been done, we've had this debate and talked about it for a long, long time, that they said, well, add it to this bill. And so we go, okay, we didn't have any objections to it. So it's bringing it to you, see if you agree with that. So you wanted to go for it.
Well, sure. So I guess my thought process being that, like, I think about child protective services, right? Whereas somebody might be called or have the title of social worker, although they might not necessarily have their bachelor's, master's, or doctorate in social work. They might be a sociologist or have a sociology degree or a psychology degree, but their title is social worker. So I'm wondering.
With the cabinet, there's two different parts. There's social service worker.
Yeah,
who's not supposed to be degreed,
That's fair.
and then they have a social worker who has to be degreed. That's the way I understand it.
Yes. That's the way I understand it too. Yeah.
Two different classifications in the cabinet. So that adds to the confusion, but at the same time, in their classification, they do have that distinction.
Having worked for the cabinet for 5 years, I don't think I wrapped my head around that. So that's.
Technically, that's the clarification.
Yeah, so, okay.
You
Look,
asked
and
for
that's part of the challenge, right? Is that when we're kind of talking about that title protection and what that means, and people who are not actually social workers telling others that they are a social worker, and not being fully prepared and educated in the way that we would be, you know, it creates a problem. And so I think we all try to navigate that. But the way the statute is written, it makes it very difficult to even attempt to navigate it.
very difficult. But
Yeah,
again,
it
this is the effort to try to clarify it in the language of the law. Because of the ambiguity, so educators asked us to include it. We were, you know, to this, I was okay, but we'll bring it to you guys, see if you're okay with that. Yeah, okay. All right,
Hank, do they have
Next,
that? Wait, before we move forward, do they have the same definition? Because I couldn't find it in my packet. The one that we spoke about, it's the one that includes the master's degree or doctorate or PhD in social work from a program accredited. And I mentioned this to Hank, and I just want to throw it out there. If we do move forward in that, we need to make sure that language reflects that the CSWE does not accredit PhD programs.
yeah, true.
They only accredit practice oriented. So the BSW, the MSW, and a DSW now, but they do not accredit PhDs.
I don't think
Well-
the DSW is accredited yet.
Did not yet, yeah, I don't think.
No, it has been. Whitney, am I wrong about this? They just approved the standards for the DSW, did they not? Yeah. We went through a pilot project, but I think they just announced it within the last couple of months that they are moving forward with that because the standards have been announced.
Yeah, okay.
So the word accredited would be the question mark, right?
Yeah, well, I think PhD would be the question mark, right? Because BSW, MSW, and DSWs are accredited by the CSWE, but the PhD, the research degree, is not accredited by the CSWE.
Okay.
So anything that's practice oriented, the CSWE claims, I don't know, I don't want to say dominance, that's not the word, but they have approval of, right? But the PhD is the traditional research degree, and they do not accredit that one.
Okay, all right.
So I don't know what that language needs to look like, but we need to keep that a little bit because the PhD is a legitimate degree.
Yeah.
And I mean, and there's DSWs are growing in numbers, but before that, we didn't have a DSW. That's a fairly new kind of degree. So you'll have many people, that will have the PhD, and it's a legitimate, very rigorous degree. And we need to make sure that that is recognized as well.
Could the language say something to the extent of accredited practice degrees and PhD?
I think it could. I think that's exactly what it should say. But I think it needs to say PhD in social work, or I don't know. There are some PhDs, Whitney, that say things like social policy and social services or something like that. So that's where I think I'm a little hung up with the language. It's still a social work degree, but they call it a few different things. I'm just not sure what that language would need to look like. So maybe it says social work, or I don't want to say related, because then you'll have somebody that comes in and says, well, I've got a psych degree. That's sort of related. And it's not. So
you check on that, and, because we need to be,
yeah, we could look at that and maybe see what.
Right here before we put it.
I wonder how many cases that applies to. Like, I know one of my friends has an MSW, but she went to Bryn Mawr, and it's called something like law and social welfare or something.
Yeah, social welfare is the other one that you see a lot of, or MSSWs, right?
That's me.
You see those
Yes.
as well, right?
Yeah.
And so maybe we need to say something along the lines of calling it the practice degrees, but then that PhD, rather than say PhD in social work, maybe we say a doctorate in social work, social welfare, social services, and we'll look at what some of that language could be. And I don't know, maybe Brinkleman can help us come up with some fancy language that if somebody pops up a new PhD that's related and we haven't thought about it, that we can make sure we're not excluding them, because we want to be, inclusive. We want to be inclusive and recognize all the hard work that our doctorate level social workers doing. But the way that it looks right now, it's not accurate. Yeah.
Okay, all right. We'll think we'll work on that one. Okay.
I'd say maybe it should probably umbrella both of them, just because I know they're starting the pilot accreditation program, but I don't think that means these programs are accredited yet. So even though they're starting the process, to say that only accredited DSWs, that wouldn't count us because our programs aren't technically accredited yet, but it's still starting the process.
Right. So, the way that accreditation works, though, if you've started the process and your program gets accredited, then yours is retroactive, right? So your degree, when that program is accredited, your degree will be considered and accredited. And we have always, if I'm not mistaken, for programs that are in the accreditation process, if someone applies and they're in that program, we've never kept them from taking the exams or anything like that. It's my understanding. Am I right about that, Hank and Whitney? You guys are been here a little longer than both of us. If the program is in the process, then, we've always erred on the side of that they're going to, that program is going to complete and they're doing what's necessary, and never kept anybody from sitting for that reason.
Very good, thank you. Anything else on that one?
Oh, I did have one.
Yeah, sure.
It's a couple of steps back though. Going back to the client definition, I wondered if we need to include something about custodian or foster. Because we have legal guardian, but I'm thinking about my time at child services. If there might be a situation where somebody's not necessarily a legal guardian, but they might have custody of the child, or a foster situation.
Good point.
Would you add temporary legal guardian? How would someone have kids under their control and
Relationship care, so it could be a relative placement to where they're not necessarily having legal, the court's okay with it, CPS is okay with it, but they might not have legal guardianship at that point.
I'm familiar with that. They do it by agreement.
Sure, and I'm not sure that even technically a foster parent would be, oh yeah, I guess that would be the guardian. But I'm just thinking about the nuance of the language. Those legal guardian is very specific.
Make it up.
That's 201. AAR.
I'm wondering though, if a child, even if they are in, and let me first preface this by saying I have never done CPS work. So, mine is what I know about it is all on the periphery. But if a child is in even in kinship care or something like that, then the state has assumed some responsibility for them.
Not
So
necessarily.
no, okay. Because that's where my mind goes to. It is that there is a guardian, a legal authority there that would be making that decision. But I don't know. I am not an attorney. That's why we have Mark B here, and I have never worked in child welfare, so I don't know.
So a lot of times, and I'm many years removed, but my understanding is there's a lot of times like, obviously, if the child is in the custody of the state, the custody of the cabinet, then yes, the state would have custody. But there might be some situations where we're able to mitigate that by saying, oh, auntie so-and-so is able to take care of this kid. But it's not necessarily a legal agreement. It's just kind of on paper, like they're agreeing to do this.
Yeah,
So
okay, I see what you're saying. Yeah.
We're overseeing the process, make sure everything's kosher, but
Because in those situations, the state still has legal guardianship of the child.
That's
but
what I thought.
With the relative.
not necessarily though.
And we've had similar situations where the auntie has educational rights, medical rights, so they can get the child care, but they're not the legal guardian. So they're still providing this care for the child as they have the right to, but they're not the actual guardian.
Well, where the auntie or the relative has the child, has physical placement of the child,
Mhm.
and the cabinet still has legal,
Correct.
the cabinet can change its mind any time of the day of week regarding that child. So the cabinet has legal authority, but the person who is exercising the custodial control is not the legal guardian. So I'm trying to understand, you want to cover that person who has custodial control, but is still not the legal guardian.
Yes, and I would also, I don't know if what you're saying is 100% accurate, because they're not always necessarily a word of the state, man. Like, it could be that, hey, we're just doing an investigation, we don't feel comfortable with them staying with mommy and daddy, so for the next couple of days, they're gonna stay with auntie.
Right.
So they're not
It
necessarily
can
a word
still
of
be
the
with
state,
someone else.
so.
But doesn't that imply, though, if they are being removed from the caregiver, that someone has to assume that responsibility? And you wouldn't automatically say that the relative that takes them in for physical custody would have the ability to make those decisions. I would have thought that that would always go to the state to be able to do that.
Not necessarily, like, it might not quite be at that point. It might just be, hey, I'm doing an investigation, and on paper, we want you to agree to do this, but it's not necessarily that they're awarded the state yet first. I don't know. And like I said, I'm many years removed, so maybe I'm just remembering.
I don't know. That is something we should probably look at, though, to make sure that those bases are covered.
At the clinic, whenever we treat pediatrics, as an individual will come in with medical rights to bring the child in to do that, but they're not the guardian.
Right.
So that person, I agree, should be included as a client, because they're the one bringing the child in, they're the one doing the treatment with the child. Like, but in this situation, yeah, they would not be included because they're not the legal guardian.
So could you cover the basis by saying a legal guardian or other person with legal authority over the child
Well,
or
it might
legal rights over the child?
I think the legal is where it gets murky though, because it might not necessarily, like, it might be me as the cabinet's making that, but it's not a judge or attorney making that. It's just a temporary. So the legal,
But when it gets to court, on that first court appearance, the judge is gonna say, what's happening now? Oh, we voluntarily placed the child with a relative.
right?
They're still giving their blessing at that point, the court.
Yeah.
I always wonder why that happens. Why does the state do it that way? And it's better to do things by agreement because they shake their finger at the family and say, if you change your mind, we will file a emergency custody order. So the mom who thinks she can get out of it and says, oh, my relative will take this child while I'm under investigation. And then everybody leaves that day happy, but the next day shows up at the relative and says, I changed my mind, give them back, you know. Then they would go to court and now we have to get a judge's order.
Right.
If you could prove the circumstances, assuming.
Yeah, and a lot of times it'd be the CP, and it's probably the honest. or don't need to get, but it might be that the CPS is making the decision, not so much that, like, we might ask, hey, who is a relative that the kids could go to? And on a temporary basis, that might happen. But it might not be official. It's not usually that mom who is in a situation where she shouldn't be making those decisions is the one that's making that decision.
So the protected classes are inclusive of legal guardian. And there's still people out there that are not legal guardian you want to make sure is in that protection.
Yeah,
I don't know how to articulate that.
temporary agreed upon party, responsible.
Well, and I
parties.
wonder, and I wonder, again, this may be a really silly question, but if it's just a temporary custody situation, like, do they really fall? And I mean, if they just bring that child to see a social worker one time, does that imply then that we also have to include them as the client for 5 years or 7 years, and they've only brought them one time? Does that make sense?
Yeah. Yeah.
Like, so would we include them and they were only like the transportation for the one visit? Because I think when we start splitting hairs like that, that's what comes to mind for me, that anybody would have brought that child to that visit because they had them temporarily, then becomes our client. And we may not even know it. If it's a teenager they're bringing, would we even know that they brought them? I think that could really muddy the waters. I don't know what the solution is,
Thank you. Good point.
but we'll figure it out. That's what we do, right? Social workers are good problem solvers.
Figure it out. Yeah. Okay, moving on to the next one definition. It's technology mediated social work service. Request is to remove it from the statute, and all references obviously to it. It was included because of, as we all know, technology is here. Social workers use technology. They don't all use telehealth, but they do use technology. And we know the one that's there, the elephant in the room, is called artificial intelligence. And that's where this comes from and why it's there. To remove it and say it's not needed, that's kind of where we're at. I mean, I just, and why did anybody read the article that said social workers are going to get replaced by AI now? We're one of the 44.
Yep.
I'm not positive about that, but that's what the research article says, but I don't think it's go that way. But anyway, I do think that we do need to have statutory reference to this because of that. It's just not there. So, do we keep it or leave it, or? It's
What page are you on?
it's.
I think we have to address it because the use of the technology prevents so many ways that our public could be harmed if it's not used correctly
Yeah.
and in the most ethical way. So it seems to me like leaving it out would be irresponsible of a regulatory board to not address that as a practice.
Okay, yeah. Hopefully, we're not gonna be, the attorney's gonna be replaced too, so just so you know, we're all, anyway.
The question again is about.
The technology mediated
Yes.
services, the definition, if we
Yes.
leave it in there, if we take it out or leave it in.
And are you wanting to add anything specifically related to AI? Is that what?
No,
you're
not
saying?
really, the definition.
Okay,
Just
just the
general,
definition
not
itself,
including,
Okay.
yeah.
So you're, I think this has got me really confused. We're including this, I know you're saying because of AI, but is this also saying that telehealth doesn't include, and I might kind of argue against that, the idea that telehealth doesn't include case management, because that's actually an area of research that I've been involved in. I would argue that case management is telehealth, just not in the same way. I just am not sure I fully understand the argument. Like not
Well,
why we should
sort of
leave it in
like-
there, but
If you look at the definition of telehealth, that's the next one, which is what we've been operating on before.
yeah.
Uh, it really doesn't necessarily include case management.
Well, our definition may
I
not,
understand
but I've
yours.
got
I
other
understand what you're
definitions
saying,
through
but-
research that does include that. So that's
I-
why I'm like,
Yeah, whereas this definition helps to include.
I would also note, for us, I think it provides an additional protection in the realm of education,
mhm,
because it speaks about that technology that might be used
mhm.
as we educate, and especially with field tracking software and things like that. I mean, if it's not used correctly, there is a potential for harm.
Mhm.
And like I said, I just think it would be irresponsible if we didn't
Yeah.
at least acknowledge that in some way, as a regulatory board.
Mhm.
But again, that's
Gotcha.
coming from my lived experience as a practitioner, and others may have something different, but it's just, what I have experienced as a practitioner and then as an educator.
What is the counter argument? I don't really guess I understand the basis of this insistence on removing that. That's the part I'm not.
I couldn't
following.
understand it either. Yeah, I
That's
Well,
my
I'll just-
question as well.
Okay, I'll give you what the statement was. The comment was, it's too complex. Let's just focus on telehealth.
don't know. I think that's one of the more clear statements that we have about what technology mediated service is.
Well, is there a concern that we're trying to do something sneaky, that we're trying to
No.
like limit
Not
something
that I
that
know
people
of.
want to
Not what I
do?
got. Yeah, not what I got, it's just that it's too complex.
Would it be helpful to add language that actually says artificial intelligence in number 8?
I think it'd be, when you start naming specific technologies, then you're gonna be naming every one of them.
Yeah.
Don't know what's gonna happen down the road. So.
Right.
We don't want to get into naming it. It's trying to be general enough to encompass anything that could still be.
I mean, we're not saying chat GPT, we're just saying artificial
Well,
intelligence.
yeah, but artificial intelligence covers a lot of ground. It covers
Right.
a lot of, it's not just chat GPT.
Well, and like I said, I think about field placement software.
It's not just chat GPT. Yeah.
There's a lot of technology we use, even doing simulations and simulated cases and things. Yeah.
When you're talking about doing virtual therapies and mixed reality therapies that are out there for a lot of people and stuff, some of it relies on just existing technology, some of it relies on artificial intelligence. And it's not chat GPT either. It's not a generative GPT. And so it's, there's different types of artificial intelligence. So
I mean, I don't quite think we would consider it telehealth. Maybe I'm wrong, but I mean, we have people that are doing therapy through text.
yes. Yeah.
And that's not covered under other things that we have. This would help to
Would help, yeah. It would help. with
cover
that.
some of that. Yeah.
Well, that would fall under telehealth for sure if it's therapy via text. But I mean, I think that this makes sense to me. I just don't want. I don't know.
Well, we'll just see what
I'm a
happens.
fan of leaving it myself. I'm a fan of leaving it.
We'll just leave it, see what we do. Okay. Next one, I just want to call everybody's attention to, because of the compact going forward, there will be background check for applicants. Because the multi-state license, even existing licensees will have to get a background check to apply for the multi-state license, but the way the language is, when you put it in, it has to be for all future applicants. So probably like from the date this law, or if it passes, the date the act goes into effect, then it will affect all new applicants. So just want to make sure everybody knew that that was in there. Some question, we probably should have had that in our law before now, but anyway.
Clarify this for me.
It has to be in a law somewhere, or we will not be able to issue multi-state licenses.
Right. So
So-
clarify that for me. Are
It has
we
to
doing
be
it?
there somewhere.
Are we doing it just for multi-state license or will we
No,
do it?
No,
For,
this
okay,
is for all, would be for all app. You can't just pick one category. You have to do it for everybody.
right. That's what I thought. And when I read it, I think I misread it and thought that it was only for multi-state license. So that's what I wanted to clarify. Thank you.
That piece of legislation will obviously have to go through, because if it doesn't, it's like our counseling compact. Kentucky can't issue any privileges because they don't have this in their statute. So that's their biggest holdup. They're probably ready, except for that piece. They don't have it in.
So here's another dumb question maybe. So for the people who are already licensed, like many of us on the board here, we already have a license. When we renew, will we need to do a background check and a fingerprinting, or are we not going there yet?
Right now, the language just says for applicants, and it's probably gonna say new applicants versus renewing applicants. Right.
Okay, all right.
Don't know how that's gonna go, so just be aware, it could come back and be for everybody, because we've already asked that question, is it gonna be, and so. Anyway.
Because it would make sense. Yeah.
Yeah, oh, yeah. Yes, sir.
Going back to the technology mediated social work service, I agree that I think it should probably stay, but are we still in a position where we can massage it? Like add some clarity to it?
We can, yeah.
And I'm thinking of the thing that I get stuck on is the any technology enabled and then modality. Maybe if there's a way of massaging those out, I think any is so broad. And then the modalities might, I mean, we don't have to get into the nuts and bolts now, but I think it's important to have reference to that as far as just, let's add clarity to it.
But just to clarify that it's, if you're gonna use it in practice, we have to include everything.
Right.
Yeah, so I mean, that's the difficulty, but we can look at it like that, so. All right, the last, two more things. One is, Mr. Nichols, about the location. There's an issue about whether the person needs to be licensed in Kentucky or not. And this would be for people providing basically telehealth into Kentucky or licensed elsewhere, and they're not necessarily members of the compact, but they don't have sponsorship license. Take it away.
Well, the concern is that the substituted language focuses on domicile, where the client is domiciled as a permissive licensor of someone who's practicing telehealth. And that the concern here is that that is contrary to the compact, that the compact focuses on where the practitioner is located and doesn't make reference to where they came from or where the client came from in this case. And it just muddies the water to the point that we have concerns about whether or not it would affect Kentucky's status under the compact.
If our laws don't stay inconsistent with the compact, then Kentucky could be brought before the commission to say you can no longer belong. Because when you join a compact, that's one of the downsides of joining a compact. It can affect other things in the way you do statutes. And this is our concern, that using domicile, because we can't find any other state that does this. They all use the location of the client, location of the provider versus domicile, domicile and licensee. Right. And we would, if somebody has a domicile in another state, we would have no way to prove that or how to enforce it. And so it's like if a person, say a family was from Ohio and they're here in Kentucky, and it doesn't say how long, but they're not here, they're not a resident in Kentucky, they, or they're on, they're here. If the child, say, reported, abuse that happens in this state to their therapist or social worker in Ohio, the Ohio social worker is not under our jurisdiction. Therefore, they would have to probably report to Ohio, and then Ohio would have to report back to Kentucky. You know, which is kind of contrary to what our mandatory reporting statute seems to try to, you know, so it would. Same with, say if somebody threshold, you know, say it was a college student from Texas, they're threatened suicide. The Texas social worker is not obligated to do duty warrant like we are. So what happens? So there's those risk characteristics that we're looking at that add to this, that, you know, we want to make sure that we're not harming ourselves within the compact, we're also protect the public on this side of it, as far as consistency.
I think this one is probably one of the easier decisions. I mean, if we're going to participate in the compact, and I think it's something that we've all talked about, and when I say all, I mean statewide, it's not just the board, something that we have wanted, then I think we have to do the language that will allow us to be a part of the compact. I think it's that simple, really.
If I'm wrapping my head around it too properly, it's more about the location of the client.
Yes, yeah.
Because, so I'm thinking of the supervisor I had before that was licensed in Kentucky, military spouse, so ended up moving to Texas for their license in Kentucky, working for a Kentucky agency, and was continuing to see people virtually in Kentucky, even though she was physically in Texas. And to my understanding, that was admissible.
That's why the compact is, it's the location of the client, but yeah, that's kind of the standard. Okay, thank you. Moving on to our most popular topic, provisional license. Okay, we've been asked to drop it completely, study it some more. We've been asked to consider an exemption, which you essentially the list of exemptions. From other boards, of course, we know our law is silent about students, and having to do something. And then we have, the provisional license, we've been asked to change the word license to permit on that one. And so what's, thoughts? We haven't read the exemption laws there from the other boards. Unless you want to just take it out completely. I mean, that's the first option, is take it out completely, which is do nothing, leave the status quo. That's the first option. Second is consider an exemption. The other one is to leave it and maybe change the word license to permit.
Do we know what in my mind, license and permit are the same thing. Do we know what the differences that they see are with the request to change the language?
It was concerned about possibly insurance billing and stuff, whereas license may have a different weight than permit, so it don't make sense.
That part I would be fine with. I mean,
Yeah, I
that's
think
a
so
simple
too.
word, and the idea is that it would be very temporary for just
Yeah.
a student who's doing a clinical placement only.
Yeah, and that makes sense. I just wondered if what they were seeing as the differences with the words, because really, I guess legally, kind of they're the same thing. We're giving permission to practice, right?
Well, permit has more of a temporariness to it, like a permit or temporary permit, or, you know, you get your permit to driver's license, it's temporary, whatever, so it would make more sense probably to call it permit.
I'd like to hear more about the exemption option. What would that look like?
Well, had some wording there.
What page?
Oh, section.
Oh.
Yeah.
Oh, good.
I'm trying to find where you sent that. I saw it, but now I can't find it in all these emails.
Yeah. That's always a possibility.
Whitney, it's in the email where the agenda and stuff is. It's listed under Kentucky. I think it says behavioral health. It says BH. It was on that.
Sheila Schuster did this for CART.
Oh, okay, gotcha. Well, I mean, my thought about an exemption, if we do put that exemption in there, we just are going to have to clearly define the scope of practice for students. And I think that that's just going to perhaps limit what they really can do. Or we may have to say a supervisor. I mean, the bottom line is students who do not have a license or a degree yet do not need to have more latitude than a CSW who has both a degree and a license. That is absurd. And also the idea that they would be practicing as a therapist with no requirement that their supervisor even be an LCSW, that is beyond absurd. So I'm not okay with that. I mean, I'm fine with exploring different options, whether it is a temporary permit or not a temporary, a provisional permit, a provisional license, or an exemption with a very clearly defined scope of practice for a student. But we can't just have it loose. We're just kind of like whatever's happening's happening, and we're it's because it's
Right.
it's
think
not
we're gonna
safe
get
for our students or our programs.
Well, and we're going to get more pushback, I think, when we start trying to define scope of practice for students than we're going to know what to do with, because
Mhm.
everybody is going to have a very different attitude or a different opinion, I'm sorry, about what that scope looks like. So that worries me about the exemption approach, and the exemption, I don't know, or doing nothing just feels irresponsible to me as a regulator anyway.
Yeah.
May have a different opinion with a different hat on, but as a regulator, it feels irresponsible.
Well, we've been getting complaints, and I think that it definitely would be irresponsible. I mean, perhaps this has been okay up to now, but we can't just not address.
Well, and that was one of the questions we kept getting from the KSWE, and they were like, well, what do you, when you mean complaints? Like they wanted actual numbers. How many have we ever gotten on that? And we can't trace that back. You know, I mean, the data just doesn't exist for us to be able to chase it back from the beginning of the board, how many complaints we've gotten in that way. And so, in my mind, though, one complaint on a situation like this is one too many. So, and to not address it when we know there is a problem, whether there's 1 or 300, to not address it is irresponsible as a regulator.
I feel like the exemption makes most sense if we're able to tighten up and clearly define it. My concern about a temporary license or a permit is that might kind of like Whitney was describing, be more like the Wild Wild West, where they're like, hey, now I got this permit, so I can do more stuff. And there might be more confusion about what they can do with that. And honestly, is it more of us making them jump through hoops and being performative about this permit that doesn't really like an LCSW exam, a CSW exam, there's a lot of studying that takes place in order to do that, which actually shows that they have a certain level of competency versus what are we actually expecting these students to, what level of competency other than they have this piece of paper, which they might be using ill-informed versus an exemption where we can really tighten up the language and say, look, these are your safety ramifications. This is your governor. This is what we're allowing you to be able to do. And we're going to protect you as long as you're doing these things.
Right, but that sounds more like what is in the statute recommendation, that it's a permit with regulations to do that with, whereas the exemption says hands off.
Oh, okay.
I think the other concern too with the exemption is that it may hamstring our students because these other disciplines are pretty loose with what they are allowing. And I don't think that's a good idea. I don't think it protects our students or our programs or the public. But I don't want them to be at a disadvantage compared to students who are in other programs. I want more social workers, not, I'm not trying to argue with you, Coin. I'm just saying that's kind of the only counter argument.
And I will say that based on our time with the Kentucky Association of Social Work Educators, we got no, we don't want this at all. I mean, there was none of that. There wasn't like a, yeah, let's do it kind of rallying support, but there wasn't a, we're not opposed to, I mean, that we're opposed to this completely. As a matter of fact, I mean, we've talked about work groups and having them involved with the provisional permit or license or whatever we're going to call it, to make sure that our educators have some input and some guidance for us on what that scope could look like, should look like, and that sort of thing. And so, I mean, I think that with the interest and what I heard anyway, and Mark and Hank were there and they could correct me if I'm wrong, but it seems like they are very much interested in being a part of this to help develop it in a way that our students are actually able to practice social work, and that we're not just expecting them come May to say, okay, well, you were limited to these things you were able to do. Now you're competent, go practice. That's just, it just doesn't work. A magic date and giving them a diploma does not make them competent. They've got to be able to practice some of these skills. For me as an educator, it comes back to competence and being able to show that competence.
And I think, too, Scott, I think the field directors are meeting later this week, and they told us
Yes.
that they would tell us what, what their recommendation is on this. So I kind of like to have their input on this piece before we.
And I will go ahead and say that a couple of the field folks talked to me and said, even if the consortium, the field directors consortium, decides that they don't want to be part of the work group, that there are individual field folks who were very interested in being part of a work group that was not associated with the KASWE Field Consortium. So there are a group of educators out there who are willing to be a part and to lend their voice and their expertise to this process of a permit or provisional license or whatever we decide to call it. So I can't say that there's, full support of everybody, that there is some support for this out there. And let's be honest, we're never going to make everybody happy with this. There's always going to be people that think this is a terrible idea or that are not going to be in favor of the process. And that's okay.
Anything?
I don't think it's something that's good anymore, so I'm not a fan of the exemption at all. Someone who has students, I can't imagine students with a full caseload, or the clients that receive care, that I just can't.
I mean, the exemption to me is like, it still leaves that open. How many clients, agencies could vote them up?
Yeah, well, an exemption is basically what is happening now, except it's just not found on paper.
right. Yeah, exactly.
We're operating as.
It's already kind of operating.
But it's just not on paper.
Yeah.
It's what's happening.
So.
I think it also gives like a framework to like somebody who might be new to giving somebody to field, like, cause it's actually been offered to me to do that for someone. To have like a framework to know that like, okay, this person isn't necessarily responsible to come in and do my caseload when they come in. Oh, you're my extra person to do my caseload.
Yeah.
No, I'm saying I'm gonna take some time, take this framework that I've been given to teach you these things. So that in May, are they gonna have full competency to practice the same way I'm practicing at 17 years license? No, but like, we can have that framework that these are the common things that we need to make sure that we have good knowledge of, or good competent knowledge of at the end. So I guess that goes against the exemption of like.
It kind of-
Yeah, so as somebody who had 2 different experiences in my bachelor's where I had like very much like, I felt like we were doing a framework in a hospital setting. And then very much in my master's where I was in a dialysis setting and I was doing that person's case list. And it was a very frustrating placement. So, yeah.
Sounds like more kind of sticking with permit, kind of idea. Okay.
And I had a misunderstanding of exemption, I guess, based off my rant. But I hear what they're saying, so I think the permit makes sense. It's just, obviously, we need to figure out how it's not just a matter of jumping through hoops and being
Right.
performative.
No,
and just
we
the
don't need
extra
to do that. Yeah.
barriers.
But I think it's where the educators are closest to where the students are at, can help guide that process. Help with the regulations.
And absolutely taking my regulator hat off and going full social worker mode or social work educator mode. I can tell you that was very much something that the group was committed to, is not making sure that this was performative or just another layer of bureaucracy for our students. That was very much a concern. And then putting my regulator hat back on from the get-go of us talking about this, that was something that we wanted to make sure we didn't do as a board too. So I think there is a common goal to not make sure, or to prevent that from being a problem.
Everybody? Okay, all right,
I
thank you all.
think the only other thing, and maybe it just bears repeating, we've said this before, but the idea of doing nothing, again, there's two steps to this process. One is that we put it in the law that says we can create a temporary permit or whatever it's going to be, not a permit, a provisional permit or license or whatever we call it. The second step is actually doing that. And so what we're talking about is not doing that. We're talking about just even having permission to do that.
Yes.
So I don't really see the utility of just take it out altogether because we're waiting for what? For the next, I mean, it just seems like that's
The next complaint.
yeah, I don't.
And doing nothing, in my mind, what we know happens is that sometimes the complaints get progressively worse. And things are going, once people find out, oh, we can report this, or we should be reporting these things, there are probably going to be a lot of things that we find out that we wish we had never learned.
Yeah, I don't want to be hasty in whatever we create. And that's not
Right.
what's going on here. And I've asked some questions about the language. I know we've talked about, like, why does it say BSW and all that? Because I'm like, we're not trying to regulate BSWs. And I think Hank's explained that's just what the drafters at LRC want in there. But I mean, that's not even the point.
Yeah, true.
Does a student too, that's like underneath somebody who's like giving them education, feel comfortable reporting to this board too sometimes? Like, hey, what would happen to me if I report what's happening to my education, what's happening
Yeah.
to all this,
We want to make sure the student doesn't feel like they're.
What's the law protection?
Yeah.
Protect.
And I think a positive unintended consequence of this is that it engages our students with our board much earlier. Some of them never engage, but this gives them an opportunity to engage and to build a relationship with the board that is kind of a dual focus to protect them and protect the public. And I think that's always a good thing. The earlier we can engage them with us, the better.
Very good.
Yeah.
Very good.
Yeah, I was like, same mention that's as far as even with the portal, like at this point, they would probably already have to have a temporary license that'd be in the portal, so when they're applying for the CSW,
Yes.
they're already.
Right.
And if they do something not so great during their time, then it's, we have that right here documented also. So that
Right.
might be.
Yeah,
So.
absolutely.
Very good. Very good. So the next item on the agenda, we're way over time, folks, and I want to be conscious of everybody's time on the board. The dates, I have the dates for, is the second Monday of the month still okay with everybody?
Yeah.
Okay, is there any particular date in March for the retreat that, just FYI, the Monday, the second Monday of May is the Monday after Mother's Day. Is that a problem?
I mean,
No.
Yeah.
I was thinking.
And then, November, I'm sorry.
I was going to ask if we would possibly consider moving to the third Monday or a different Monday, only because it seems like the second Monday almost always falls in the months where we go to ASWB.
Well, that's
We-
November. Yeah, so, yeah.
I don't know. I mean, Mondays are better for me because we teach on Tuesday, Thursday, but
Yeah. Mondays are good for me, so.
Yeah, that's fine.
I can handle it. Yeah.
Yeah.
Third, or keep it on the second.
Third, Whitney has a good argument for third, and I have no
Yeah.
feeling it
Yeah.
either way.
so that would start in January or February or Sydney.
You would start January. yeah.
January.
Yeah.
Is the retreat typically the Sunday before the meeting?
Yes.
That would be more a conflict for me,
Right.
just for me.
Yeah, but that's where it's like, we've looked at other weekends.
Okay.
And if we
Yeah,
do
we
the
can
third,
change the retreat.
do the third Monday, then we would be doing the following.
That's a holiday in January. That's Martin Luther
That
King.
one month is the only conflict I have.
Okay.
Second or third.
The second Monday, well, it's not so much the meeting as it is
Right, that would be the 15th of March if we go through the third.
Yeah, that's fine. It's the eighth, seventh, eighth, the week of the seventh and the eighth, that's
Yeah,
it.
okay. Yeah, 15th is probably,
Okay.
so, but we'll see, we'll see.
If we move to the third, is that gonna put us on too many holidays? Cause in January, it's Martin Luther King, in February, it's President's
know,
Day,
that's
and I know
crazy.
some people, we could do the
I know
first
it.
Monday, we could do the fourth Monday, I don't care, but the second
Right.
Monday is not.
The federal holidays are great for me because I don't take time off to work.
Right.
Okay,
Like today's Columbus Day and I'm here without having to take leave.
okay,
Unless statewide shut down, then it's problematic, obviously.
Okay,
We'll know those
we'll,
holidays.
we'll put some dates down and then
Probably about
finalize it next month.
Okay.
Let's put some dates down again and see where we at then. So, that's it, we can check off some places. We can read places,
So third Monday,
yeah.
and then in March, just check
Yeah,
on places,
Yeah.
what areas we're going
Yeah,
to look
yeah,
into.
just check on some
Or
city areas. Yeah.
You'd re-
Right, what, like, what part of Kentucky,
Central,
central? Okay.
B-town. No.
or Louisville, I mean, Louisville's pretty central, I don't,
Louisville's pretty central.
Yeah, I know, well, that's pretty good. Yeah,
Awesome.
might be able to go, let's try a little. Let's do a little.
And that's the third weekend in March or at a different?
Yeah, it's what we're looking at right now.
Okay.
Yeah. Okay. All right, time, everybody, it's 1:30. We have new staff evaluations. We usually go into closed session for that, and we have, visitors here. Instead of, I'd like to move that up, so if anybody needs to say anything, they don't have to wait for us to come out of closed session, and we can in and they can be on their
Appreciate
way.
that.
If that's,
Thank you for
if
that.
that's all right,
Yes,
with everybody here. So, and, you know, in the interest of times, if you can, please keep your comments short for the rest of us, if it's all possible for you, so. I know who, Carolyn, you want to start?
Yes, sir, if that's okay, and I promise, I respect for everybody's time, I'll be very brief. I want to say already, thank you so much for allowing us to attend today. I feel like I have learned a tremendous amount about the inner workings of the board and questions that we can't even imagine are being posed as you all face redrafting and updating legislation, so. And this will be a brief statement that I'm reading that I do have copies of for everyone.
Sure, I'm sorry, I missed your name. and where you-
Carolyn Lee, LCSW.
Okay.
I'm in private practice in Lexington. I'm also the advocacy chair of the Kentucky Society for Clinical Social Work. The Kentucky Society for Clinical Social Work and the National Association of Social Workers Kentucky chapter support the efforts of the Kentucky Board of Social Work to update and modernize the regulations that govern social work in Kentucky. We thank you for all of your hard work in helping to prepare Kentucky for the Interstate Compact, which will increase service opportunities for Kentucky LCSWs. The telehealth components also clarify standards and support the modernization of social work practice. The only area that KSCSW and NASW Kentucky have any concerns about is the proposed provisional licensure for students, and we've requested this be removed from the proposed legislation. Our concerns are insufficient evidence. KBSW has provided no research, no data to support the idea that provisional licensure improves access to care, increases public safety, or protects students. Regulatory changes of this magnitude require measurable, evidence-based justification. Supervision capacity and standards. Although weekly LCSW supervision for MSW students is required, the proposal lacks clear standards for safety, for training, documentation, considerations for rural areas, thereby risking public safety. KSCSW and NASW Kentucky support most of the Kentucky Board of Social Work's 2026 legislation. The proposed bill supports the goal of strengthening and modernizing the social work field in Kentucky. KSCSW and NASW Kentucky fully support our Kentucky social work programs and the educators as they continue to lead the way to engage, empower, and educate our future social workers. Here are our recommendations for the 2026 legislation. Convene a multi-stakeholder work group, including KSCSW, NASW Kentucky, and KASWE. educators, students, and rural providers before making any regulatory changes. Any provision regarding student licensure must include a narrow scope of practice and prohibit students from functioning as CSWs or LCSWs, especially BSWs. I promise to keep it brief. I have lots of opinions and lots of things to say, but these are the bullet points. I have a copy to hand out for each of you. We also have some other wonderful social workers here today with us to share their concerns. Thank you for your time.
Thank you. I mean, there's,
I just
hopefully,
wanna
if there's
say-
anything different from what you.
Everything's different.
Yeah.
That was my original piece.
Okay. All right, thank you.
We just want to add to the exemption, since social work is the only mental health board that does not have an exemption. We're gonna need scope of practice regardless. So what we respectfully ask is that you all do explore that exemption piece. That way it doesn't put students in that line of fire in terms of having a provisional license and having to come before the board. There's a lot to be said for scope of practice. I know there are many in this room who know how hard I have fought for there to be guardrails and scope of practice, and I think that's critically important. Any way we move with the exemption, I think may be an easier way.
I think I want to be perfectly clear that with this, a client who sees a student clinician is covered by a system of safety and accountability that is arguably stronger than standard practice. I think that there are three essential client safeguards. The power of licensed supervision. The most critical safeguard is that the student never practices alone. Every clinical hour, every assessment, and every treatment plan is guided and approved by an LCSW. This supervisor is the clinician of record and is legally and ethically responsible for the client's care. This intensive dual oversight structure ensures professional quality. I also think the student needs their own malpractice insurance. In the issue of mandatory transparency, clients have a non-negotiable right to feel full disclosure. They must clearly be told that their clinician is a student and they are given the name and the credentials of the supervising profession. Clients can refuse student services and request fully licensed staff members instead, with no impact on their continued care. Their choice is always protected. The third tier of this is absolute ethical compliance. Students need to be bound by the highest professional standard, the NASW Code of Ethics. They need secured confidentiality when they present case material related to the client, to be sure that the client's information is disguised in any training session. And there is the duty to protect, that the student is legally required to report imminent threats of harm by the client as well as others, making public safety the underlying priority. In summary, a client seeing a graduate student is receiving care that is rigorously monitored, transparent, and ethically secured at every stage of treatment. Thank you for your time.
Thank you.
Oh, well, I'm Janice James. I'm not with any organization, but I was on the board for a long time. I'm sure I told y'all, and I was involved with ASWB. So how I am here today is that I kept getting all this information that the board was moving in a direction that neither NASW, the clinical society, and the academia supported. Now, obviously, some academia support it because I've heard it here today. Somebody had a letter saying that on the 16th that they are meeting to formally decide if they want to, I guess, endorse this or ask for other accommodations. So my only point was, obviously y'all are doing some hard work. This first time I sit on the side and I like the dialogue, you're informed, you obviously put a lot of energy to exploring this. But I just never heard of the board going in a complete opposite direction of all the organizations. Now, it seems to me like there's a little bit more support from some people in academia. So my position was, one of you mentioned, to take a little more time and examine it. I noticed in your documents on the board site that no other jurisdictions with ASWB have this right now, that Minnesota is also proposing it.
Yeah.
So you'd be
Well,
cutting edge.
Yeah, we're gonna get, to just say Minnesota is now backtracking.
Oh, it's back. So that's what I was saying. You'd be cutting edge. So, you know, one of the things I always did, I always like to learn from other people. So you get no benefit from lessons learned by going forward at this time. If you, ASWB, I guess they still have the model law. I assume this is not in the model law, if none of the other, do they still talk about the model law with that? They don't talk about that at the trainings? Because that used to be a big piece. They have this law that they sort of hold out as a standard so that everybody can try to gain as much unity as possible. You know,
Yeah, we got it, the book.
yeah, so I'm assuming there's no, at this point, that it doesn't contain the provisional license, so. My point is, we all want the same thing. We want the public protected, and we want us, as much as possible, to be on the same page. So that was my only, reason for coming here, and I really am happy to sit in and watch your operation today. It's really good.
Thank you, thank you.
I don't think anybody else from my group has comments. We appreciate your time, though. Thank you.
Yeah, thank you, and just clarification, you can come anytime. Okay, you don't have to have a special invitation.
I'm
You
like,
come
glad to
anytime.
you, so I would love to just
Yeah.
start seeing what you all do. There's a lot of good work going on here.
Just show up at any meeting, so.
I will just say that I'm a member of the field consortium of KASWD. I'm a clinical faculty at the University of Kentucky. And so I've been involved in that, and I attended the KASWD meeting, virtually. And this week we, are reconvening post KASWD to discuss further. I'm not sure an official stance will be coming out of that meeting or not, and I don't speak for that consortium.
I don't know either, we just knew that you were gonna be meeting.
Yeah, we will like it. We will be talking about it further.
That's, and we're glad.
Yeah.
Want you to be talking
Absolutely.
about it further.
It's vital to me that we included an educator in our conversations.
Yes,
So.
sure. And that's the critical piece, and you weren't there for the afternoon session. But at KSWE,
I was not, no, I only attended.
we had a really nice, a further discussion.
I'm sure, yeah.
With the educators, and they kind of like they were appreciative that the board was including them in the process. And I think somebody commented that they didn't remember that ever happening. I don't know if it did or not, but you know, I think somebody made that comment. So we were glad to have the morning session as well as with field educators, as well as with the rest of the group.
And if I
For
may
folks
add,
that weren't, I'm sorry, for folks that weren't able to be there, I am from the University of Pikeville, and I did take the initiative to make sure that that meeting was recorded. And I think it is on the board's website. It is also on the KASWE website, or on our Facebook page rather. If you would like to go and watch that dialogue and watch what we discussed. We wanted there to be full transparency and to share what the opinions were. And so you can go access it there if you haven't already.
Okay, good. Thank you very much. At this time, I would entertain a motion for a closed session or a course evaluation.
So moved.
Okay, in a second.
Second.
All right.
That would be under KRS 61.810, parent 1, parent F is in Frank. 61.810, parent 1, parent F, for the appointment, discipline, or dismissal of an individual employee, and general personnel matters are not permitted.
All right.
So how do we do the YouTube?
Hank, I'm gonna have to step. I've got to go.
Yeah,
I've got another
I know,
meeting.
I know.
I'm sorry.
I'm sorry.
No problem with it.
Okay.
All right, you just kill just click the mic button and the video button at the bottom. probably can't hear us either.
Can you,
Uh,
you can hear us,
Janessa?
could you?
Janessa, call me on the phone, please.
Gotcha.
Give you the option to stop it. Hank.
Yeah, just stop it, just
stop
no, kill the video, well, at this point,
Do the whole Zoom,
just kill the whole thing because we're gonna do the closed session, we gotta come back and,
and then we're gonna adjourn.
yeah, we're gonna adjourn when we come back, so just kill it. It's